Linux then is the operating system for free, started by Linus Torvalds back in 1991, donated to by thousands of people around the world, but significantly donated to by major vendors that have contracts with us. If you look at the effect of Linux from over the last 4 years, if you look at where it was in 1999 versus where it is right now, you see a quantum leap up in terms of the capabilities. Whereas in 1999, this was a hobbyist level technology, very simple multiprocessor capability, and moderate degrees of reliability. When you look at Linux today, the 2.6 kernel just released here in December, you see enterprise level performance. You see 32-way multiprocessor SMP configurations, 128-way NUMA configurations, high degrees of reliability. In other words, you can take Intel processors with today's versions of Linux, and because of contributions major vendors have made, establish a supercomputer level configuration with Linux as the base operating system. It took the Unix environment, development environment, 25 years to get this kind of capability. Linux has got there, has been able to get there in just a few short years. So that's at the heart of our IBM lawsuit. Now, after we filed a lawsuit against IBM, they countered against us, and basically at the core of their counterclaim against us was this thing called the general public license. And if you look at the general public license, you basically see an instrument there that is designed to make software available for free. And because we were involved in the Linux environment along the way, we're not currently, then their claim is, oh, you gave this stuff all away. If you look at some of the issues that surround the GPL, we think they're fairly significant. The founders of the GPL, the Free Software Foundation, have this notion of copyleft. And copyleft is designed to be exactly opposite of a copyright. Whereas a copyright is designed to protect your property, to be able to give you proprietary rights, something you can go license for and charge a fee for. With the copyleft, the idea is this is a free work. It's something that you don't charge a fee for. And in fact, over time, you have everybody sort of getting into this free sharing mode of software. And they believe adamantly over there that proprietary software is evil. I mean, the words they use, it is evil. That proprietary software is bad for the world. Those are the words that come out of the free software camp. That issue becomes significant because, again, if you go back to Eldred v. Ashcroft, these same arguments are made in the Supreme Court hearing. And in the majority opinion, again, I forget which justice wrote this. Is it Ginsburg? The statement is made, the copyright law celebrates the profit motive. And in fact, the profit motive is the engine that ensures the progress of science. The GPL has had no significant court test up to this point. IBM has put it on the table in our case, and we expect that it is going to see a major court test as we go through our litigation with them. To speak again back to the minority opinion, Justice Breyer's opinion was that copyright statutes must serve public, not private ends. The majority response to that was, this misses the mark. Copyright law serves public ends by providing individuals with an incentive to pursue private ones. So I think, again, this is a major issue that we're going to see coming out as we go through the litigation battles. Now, another really key, interesting point about this general public license is the lack of indemnification. We are moving now through our court-related issues. You're going to see we have a litigator by the name of David Boyce, you may have heard of. And as we go through our situation with our feeling that in the IBM case we had our contracts we felt were being violated. In the copyright situation, the question is, who do you go after? The open source software world is very interesting. There's a string of players there. You have Linus Torvalds that accepts a bunch of changes, a bunch of code, and includes them in a version of software. Then it comes down to distributors of the software like Red Hat and SUSE. Then it comes down to a hardware player like an IBM. Eventually it ends up in the hands of an end user. But if you read the GPL language, it says, so if you're a user now, a buyer, I guess you don't buy because you're receiving it, the GPL language, when you get a Linux license, says because this program is licensed for free, there is no warranty. And so the entire risk on this is on your shoulders. So we have basically said within the next few weeks, by February 18th, we are going to be in the courtroom with an end user to go through the copyright-related problems that we are having from an infringement standpoint. The free software response to SCO is, you guys are crazy. This would be like, I believe Professor Moglen is quoted as saying, this would be like going to Barnes & Noble, getting a book, going home, and while you're sitting on your couch in front of the fireplace reading it, SCO comes in and sues you for reading the book. That's lunacy. You can't sue somebody for reading a book. Okay, but I would point out there are two major differences in the case of Linux compared to his Barnes & Noble example. The first major difference is that you didn't buy the book in this case. Let me grab my little GPL license here. In the case of Linux, again, as it says here, this is licensed free of charge. So you didn't actually pay anything for the work. But at the same time they gave it to you, they said, by the way, if somebody comes after you because there's a problem with this, if there's an infringement, if there's a problem, then you're on your own. Don't come back to us because we didn't receive any compensation. You're on your own. The second major issue is that in the first example, when you're sitting at home reading the book, it sounds fairly innocuous. If you look at how Linux is playing out in customer environments, when people receive Linux, they don't typically just receive it and use it. They typically receive it, use it, and then copy it. Many of the organizations we looked inside of have gone out and got a license for Linux, and they've copied it around another 9 or 10 times for each version that they receive down. So this would be like the Barnes & Noble user reading the book, enjoying it, getting up, and then going out and making 500 copies and spreading it around to their friends and neighbors. Okay? That's our point about it being a copyright problem at the end users, at the end user level. And so, again, on these key points, we're going to be highlighting them in some end user lawsuits. And, again, the courts are going to be helping us sort through all of that. As we have put these plans in place and stated that we are going to be going into the end user litigation side of things here soon, a number of vendors have stepped up and said, we're going to provide SCO protection. Okay? If SCO sues you with a lawsuit, we will provide you protection. Now, typically, the protection revolves around you pay us some money, and then if SCO sues you, then we'll give you some money back. In Novell's case, I believe they give you a little bit of a premium on what you pay them. But at Linux World here a couple of weeks ago, a prominent technology publication was saying all the vendors were trashing each other's indemnification programs. Basically, what you start realizing here is this free software is starting to become not so free. People are now going to users saying you need to pay money, and then we'll step up and protect you.